A new federal class action lawsuit was just filed against the Law School Admission Council. That is the nonprofit that runs the LSAT, the Credential Assembly Service, and the whole back-end system that law schools use to process your application. Now, this is not just someone ranting. This is a formal complaint accusing the Law School Admission Council and the law schools behind it of creating a system that locks out competition, keeps prices high, and shifts the costs entirely onto applicants. And, according to the lawsuit, this could actually violate federal antitrust laws. Now, to be clear, these are just allegations, not proven facts. But they are serious allegations, and if you've ever wondered why applying to law school costs so much, this lawsuit lays out a possible answer. Now, to be fair, LSAC is technically a nonprofit. Their stated mission is to, quote, promote quality, access, and equity in law and education. And to their credit, they've made the application process a whole lot easier than it would be if every law school had their own system. But this lawsuit paints a very different picture. It argues that LSAC's central role and its direct connection to law schools has created something that looks less like a helpful admissions tool and more like the only toll booth on the road to becoming a lawyer. And when we work with students, we see how frustrating that toll can be. It's not just the cost, although that adds up fast. It's the lack of choice, the lack of flexibility, the feeling that you're playing a game where all the rules were written without you in mind. And so now this lawsuit is forcing a new conversation, not just about prices, but about power. The question of who really controls law school admissions and what would happen if that control were challenged. So let's break this down. The core of the lawsuit is not the LSAT or whether the test is fair or not. It's about something way more structural. Who pays for the law school admission system and who benefits from it? Now, here's how it works right now. If you want to apply to law school, first you've got to pay $215 just to open your Credential Assembly Service account. That's your CAS subscription. Then it's $45 per school just to send in your information. And on top of that, each law school usually charges you $75 to $100 in separate application fees. So if you apply to 10 schools or more, which is pretty common, you're spending well over $1,000 before you even get a decision back. And no, there is no refund if they say no. Now here's where the lawsuit gets interesting. According to the filing, none of that LSAC money ever makes it to the schools. And the schools don't pay LSAC to use their platform either. LSAC provides this entire admissions infrastructure to law schools for free. And I don't mean free as in a free trial. It is fully featured, fully integrated for free. Whether it's document management or communications or enrollment reporting, law schools get full access to LSAC's back-end system called Unite without paying a dime. And so, where's the money coming from? According to the lawsuit, it's coming from you. Here is the direct quote from the complaint. Quote, applicants' Credential Assembly Service fees are the sole fees paid by anyone for LSAC's law school application platform. That's on page 9, by the way. In other words, every dollar that funds the admissions platform comes from applicants, not from the law schools, not from outside sponsors, but from you. And this is not just a financial thing, it's a power thing. Because when one organization controls the only system for applying, sets the pricing, and is governed by the very schools you're trying to get into, that's not just centralized, that's tightly held. Now let me pause here for 1 second and say, LSAC never hid this. This model has been in place for years. The lawsuit is just putting a spotlight on it and asking whether it's operating as a monopoly. And from what we've seen with working with students over the years, this setup can feel incredibly frustrating. Not because LSAC's out to get you, but because when you hit a snag, there's nowhere else to go. No alternatives, no competitors. It's a single point of entry for everyone. And while standardization has its benefits, it also comes with trade-offs. And one of them is this. If the system's expensive or confusing or slow to adapt, you're kind of stuck with it. And that's what this lawsuit is challenging. Not the LSAT, not the idea of centralized admissions, but the assumption that this is the only way it can work and that applicants should keep bearing all the costs. Now let's talk about who actually controls all of this, because this is the part that most people, even smart, well-researched applicants, don't realize. LSAC is not a neutral third party. They're not a government agency, and they're not some independent admissions tech startup. It is a membership organization, built and governed by the law schools themselves. According to the lawsuit, and again I'm quoting directly here, LSAC was created and is operated, maintained, and controlled by its member law schools. And just in case that wasn't clear enough, the complaint also says every member of LSAC's Board of Trustees works for a member law school. So think about that for a second. The same people deciding how the application system works, how much it costs to use, what the rules are also the ones running the schools you're applying to. It'd be like if Amazon ran the entire job board for every tech company in the country and then charged applicants $45 just to submit a resume to each one. On the surface, it looks standardized, efficient, even fair. But under the hood, the people setting the prices are the ones who benefit from keeping those prices exactly where they are. Now again, in fairness, centralization has upsides, and law schools, to their credit, do need a system that keeps applications organized. Nobody's saying they should be reviewing PDFs emailed in at 2 a.m. But the lawsuit argues that this tight relationship, where the schools control the platform that charges applicants, and applicants have no choice but to use it, creates a closed market. And that's a market where prices can be fixed, alternatives are shut out, and innovation gets stalled. And from what we've seen with our students, that lack of flexibility leads to real stress, not just financially, but logistically too. You don't get to choose how or where you apply. You just do it the same way everybody else does because it's the only way available. And that's exactly what this lawsuit is questioning. Is that structure helping applicants, or is it just protecting the institutions? So now we get to the core of the lawsuit's argument. This is not just about high fees. It's about how those fees are structured and who's benefiting. Here's what the lawsuit claims. Quote, the member law schools directed LSAC to provide LSAC's law school application platforms to the schools at no cost. Meaning, law schools do not pay to use the platform. They get it for free. And they're the ones who helped design the system in the first place. So who's footing the bill? You are. Every time you pay $215 for credential assembly service and $45 per school, you are funding the system that law schools use for free. And beyond that, law schools are actually getting money back from it. Quote, between 2013 and 2023, LSAC distributed over $6.5 million in grants to law schools, over $300,000 to Indiana University alone. Now, I want to be super clear. That doesn't mean there's anything illegal about that on its own. But the lawsuit argues that this structure creates a conflict because the more applicants there are, and the more they spend on credential assembly service and report fees, the more money LSAC has to distribute. It's like running a bake sale where the bakers eat for free and the customers get charged extra to cover the cost of the venue, the cupcakes, and the catering. And we've seen this up close. When we work with students applying to lots of schools, the number one question we get after which schools a reach is almost always, how many can I afford to apply to? And that's the kind of mental calculus that no one should have to do at this stage. And here's what makes this lawsuit more than just a technical antitrust claim. It's about access. And I know you might be thinking, maybe this is just how it has to be. Maybe there's no better way to do it. But the thing is, there are alternative models out there already. Take undergrad admissions, for example. You've probably heard of the Common App. That's the platform that high school students use to apply to college. It's used by over 1,000 colleges. It lets students submit one core application to several different schools, and it's free to students, and schools are the ones who pay to use the platform. Now compare that to LSAC's model, where you pay $215 just to open your file, then $45 per school to send your application, and then an additional $75 to $100 in school-specific fees. So basically, we could flip the entire financial model upside down. And the lawsuit points that out directly. Quote, unlike LSAC, the Common Application does not charge applicants any fees for its application platform. Instead, the Common Application charges member schools. Now here's another example. Business schools use decentralized systems. They compete for applicants, and some charge as little as $30. Others will waive their application fees entirely. As a side note, some law schools waive their application fees entirely as well, but LSAC typically is not waiving any fees. But my point here is that it's not like there's no other way to run this. It's just that law schools don't have to run it any other way because every single one requires you to use LSAC. From the complaint, and I quote again, every member law school requires applicants to submit applications electronically through LSAC. No member law school permits applicants to apply using any other electronic processing method. Translation: there's no competition, there are no alternatives, and there is no incentive to lower costs or improve the platform. It's like being told there's only one airline you can fly, and it charges a mandatory boarding fee just to look at the ticket prices. And so, when we help students build their school lists, one of the most frustrating things we see is this. Even if an applicant is super qualified, even if they've worked for months to crush the LSAT, their hands are still tied by the number of applications they can afford to submit. And this lawsuit paints a picture of why that might be by design. And that's where this stops feeling like just how the system works, and it starts feeling a little bit more deliberate. Now let's zoom out for a minute, because this is not just about one platform or a few extra fees. The lawsuit argues that the entire market for law school applications has been structured in a way that benefits the institutions while putting the entire financial burden on you. Here's the language they use, quote, "The law school's price fixing through LSAC has created a market where the application platform fees cost the same no matter the law school to which an applicant applies. This would not be the case in a competitive market." So let's break that down. In a normal market, let's say you're booking a flight or buying shoes, different providers compete. And that competition means lower prices, better service, and more innovation. But here, every law school uses the exact same system, same application platform, same credential assembly service fees, and same structure. And because of that, there is no incentive to change. Schools don't have to improve the user experience. They don't have to offer better tech. And they don't even have to think about the impact on applicants because from their perspective, it's all taken care of at no cost to them. And just to make sure we're being fair here, again, yes, centralization has benefits. It saves the schools the time and money of building their own systems. It helps standardize transcripts, rec letters, and all the other data. But the lawsuit's saying that convenience is not free. It's just been offloaded entirely onto applicants. So what does this lawsuit actually want? Let's talk remedies here, because they're not just saying, hey, things feel unfair. The plaintiffs are asking the court to force real changes. According to the filing, they want, among other things, injunctive relief. Basically, this means a legal order to stop the alleged price-fixing arrangement between LSAC and the law schools. They want treble damages. That means triple compensation for every dollar applicants were allegedly overcharged. They also want structural changes, like allowing other platforms to enter the market so law school admissions actually becomes competitive. And if the lawsuit succeeds, what could that look like? Maybe we see multiple platforms for law school applications like the Common Application. Maybe law schools start paying for the platform rather than the applicants. Maybe application fees will start to vary a bit more and schools will compete to attract you. And maybe the whole process finally starts to feel a little more transparent and a little more applicant-centered. Now, let's be realistic. Lawsuits like this can take a while. They could take years because things move slowly. There are motions, hearings, responses, and counter-arguments. And even if the plaintiffs win, implementation is not going to happen overnight. But that's not the only point here. The point is, for the first time, someone is formally challenging the system that tens of thousands of students have quietly accepted as just how it works. And they're doing it with legal arguments, financial data, and detailed allegations, not just Reddit posts and frustration. Now, I'm not saying this is definitely going to change everything or anything, but it could. And we always tell our students, understanding how the system works is one of your greatest advantages. Because it's hard enough to get into law school, you shouldn't have to navigate a closed market just to apply. So here's another big question. If this system has been in place for years, and if tens of thousands of applicants go through it every cycle, why hasn't anyone challenged it before? According to the complaint, the answer is simple. It's complicated and opaque, and no one really knew who was responsible for what. Applicants don't have time to dig into who's on LSAC's board, how the platform is funded, or whether the law schools themselves are shaping policy behind the scenes. You're busy writing your personal statement, studying for the LSAT, and trying to figure out how many schools you can afford to apply to. And for the longest time, that lack of transparency made it hard for anyone to take legal action. But now this lawsuit is saying, let's look at the entire structure. Not just the fees or the clunky tech, but the relationships behind it, and how those relationships might be keeping out competitors, inflating costs, and limiting your choices. Here's another quote straight from the lawsuit. LSAC has constructed illegitimate and insurmountable barriers to entry for competitors by structuring its platform in such a way that competitors have no feasible way to access potential customers. In plain English, it means if this system were a toll road, it's not just that they set the price, it's that they built the only road and then locked the gates. Now again, not saying it's illegal, but that's what the plaintiffs are arguing, and the courts are going to be the ones who ultimately decide. But what matters for you, as someone who's applying to law school, is that this is the first real challenge to a system that hasn't been touched in decades. And it's raising questions a lot of people have had for years, like, why is there only one platform? Why do I pay all the fees when the schools benefit too? Why aren't there any real alternatives? And so this lawsuit is putting those questions into legal terms. Now let's zoom out for a second. None of this means the system's going to change overnight, doesn't mean LSAC's going away, and it definitely doesn't mean you should stop applying. But it does change the conversation. Because now when people say, why is the process so expensive? Or why can't we apply another way? There's an answer. Someone is finally challenging the price of admission. And that's something every applicant, whether they're applying now or 5 years from now, deserves to know.